You might think corruption is always about cash in an envelope, but under Article 245 of the Revised Penal Code, the currency is much more personal. We're diving into a set of legal sources today to define abuses against chastity by public officers.
Yeah, and our goal for this exploration is really to unpack how the legal system draws a hard line when someone in power tries to use their official weight for immoral ends.
Right, because it's not just a moral failing, right? It's a very specific breach of public trust that triggers criminal liability in, well, 3 distinct ways.
Exactly. And what's really fascinating here is that the context of power is everything. To even trigger Article 245, I mean, the person making the move has to be a public officer.
So this isn't just about 2 private citizens having a dispute.
No, not at all. We're looking at individuals who hold a position of authority and actively choose to make what the code calls unchaste and immoral advances.
I noticed the sources use the word soliciting for that. Does that mean, like, if someone makes one off-color joke or a clumsy comment at the office, do they suddenly end up in the crosshairs of this law?
Well, no. The bar is definitely higher than that. Legal interpretation requires the proposal to be earnest and persistent.
Earnest and persistent. So more like predatory behavior, not just an accidental remark.
Right. It's someone using their status to actively pressure a woman. And that pressure usually happens in very specific environments.
Yeah, the first scenario the code outlines is when a woman has pending matters before the officer. So it really feels like the officer is essentially holding paperwork or even a life-changing decision hostage in exchange for a favor.
That is a perfect way to view it. And the second scenario is even more direct. It involves custody.
Like a warden or something.
Exactly. A warden or a police officer who is charged with the care of a woman who is either a prisoner or under arrest. They are in absolute, total control of her environment.
But the reach of this power actually goes even further than the person sitting in the cell. The third scenario covers the relatives of someone in custody.
Yeah, a wife, daughter, sister, or even someone related by affinity. And that affinity part is key.
Right, because that means it's not just blood relations. It extends to relatives by marriage, like a sister-in-law.
Precisely.
That is a massive reach. It's essentially saying an officer can hold an entire family's dignity hostage just because he has the husband or the brother behind bars.
It really is.
But let's get into the mechanics of proving this. If it's a he said, she said situation, and there's no recording, how do you actually catch someone?
This is where we have to look at the work of legal scholar Reyes and the concept of consummation. In a legal sense, the crime is consummated, meaning it's legally complete the very moment the proposal is made.
Wait, so you're telling me the crime is fully realized the second the words leave his mouth?
Yes.
Even if she says no and walks away?
Exactly. The damage to the integrity of the office happens the moment the officer tries to trade his authority for something immoral. It doesn't matter if she accepts or rejects it. The act of asking is the crime.
That seems like a really high bar for a prosecutor, though. What if there is no witness to the proposal, but the advance actually happened?
That brings us to the Morelos exception, from the case UF versus Morelos. You can think of this as a sort of loophole closer.
Okay, how does that work?
The ruling basically says that if illicit relations actually occur, the crime is proven even without separate evidence of a prior proposal. The act itself serves as the proof that the abuse of power took place.
So the logic is that the relationship simply wouldn't have happened without that underlying abuse of the official's position?
Right. It simplifies things because you don't need to find a paper trail for a spoken proposal if the end result is already visible.
That makes a lot of sense.
The linchpin for all of this is the connection between the woman and the officer's official duties. Without that link, whether it's pending business or custody, it might be a different crime or a moral lapse, but it wouldn't be this specific abuse of authority under Article 245.
It really underscores that this law exists to protect people in highly vulnerable legal positions from being exploited by the very people meant to uphold the law.
It does. But it also leaves us with something interesting to mull over. By including that affinity clause we talked about earlier, the law recognizes that an official's shadow is much longer than we might think.
Yeah, it really makes you wonder. If the reach of authority can impact an entire family's honor, are there other areas of law where we should be looking at affinity to define the true footprint of a public officer's power?
You know, we trust people in positions of power to uphold the law, right? But what happens when they're the ones who break it? Today, we're going to look at a pretty unique law, one that's not designed for the average person, but as a specific check on authority itself. It's a law that draws a really firm line in the sand against the abuse of power. So let's just jump right in with the big question. What happens when someone we've entrusted with a public office uses that power, not for the public good, but for their own personal gratification? It's a really disturbing thought, and thankfully, the law has a very specific and very powerful answer. And that answer, well, it comes in the form of Article 245 of the Revised Penal Code. And its title, Abuses Against Chastity, it really doesn't pull any punches. As we're about to see, the law doesn't just see this as bad behavior. No, it sees it as a deep betrayal of public trust, a crime that is born entirely out of an imbalance of power. So what exactly are we talking about here? In the simplest terms, it's when a public officer uses their job, their authority, their position to pressure a woman who is in a vulnerable spot. The absolute key here is that direct link between their official power and the immoral advances they're making. Okay, so the law really boils this all down to two essential parts. It's pretty straightforward. First, the person doing it has to be a public officer. This law is specifically for them, not for just anybody. And second, the act itself, soliciting or making immoral advances. So let's really dig into what that actually means in the eyes of the law. All right, so we've nailed down the who. It has to be a public officer. Now let's get into the how. What exactly does the law consider the criminal act? The language here is incredibly specific, and for a very good reason. Let's look at this word, soliciting. In legal terms, it's not just a casual one-off comment or a bad joke. The law defines it as proposing something immoral earnestly and persistently. That phrasing points to a deliberate, almost predatory intent, not just a simple lapse in judgment. It's a pattern. And this is where things get really interesting. This shows how the law adapts when things get more serious. A huge case, U.S. versus Morelos, set this powerful precedent. If the abuse escalates all the way to sexual intercourse, the prosecution doesn't even have to bother proving the whole persistent proposal thing. Why? Because the act itself becomes the undeniable proof. So it's really important to get this part. This law is incredibly precise. It's not some broad catch-all rule. Instead, it's laser-focused on situations where a public official holds direct, undeniable power over a woman's life or her circumstances. The law actually lays out three very specific groups of protected people. First, a woman who has a case or some official business that officer is deciding on. Second, a woman who is literally in that officer's custody. Think of a prisoner. And third, the female relatives, the wife, daughter, or sister of someone in that officer's custody. You see the pattern, right? In every single one of these scenarios, the power imbalance is just massive and totally undeniable. Okay. This brings us to what is, for me, the most critical and honestly the most stunning part of Article 245. At what exact moment is the crime actually committed? When is that legal line officially crossed? And here it is. The crime is committed by the proposal alone. Just let that sink in for a second. The woman doesn't have to agree. No physical contact has to happen. The second that a public official abuses their position to make that immoral proposition, the crime is done. It's complete, because the real offense here isn't about the outcome, it's about the abuse of authority itself. So after all that, why does a law like Article 245 matter so much? What's the big takeaway here? Because this goes way beyond just punishing one person. It's about protecting the very foundation of public service. So, to wrap it all up, this law does a few really vital things. It holds public officials to a much higher standard than the rest of us. It acts as a crucial shield for people who are in these incredibly vulnerable positions. And most importantly, it shifts the focus away from the tricky question of consent and puts it squarely on the abuse of authority. By making the proposal itself the crime, it sends a clear message. The integrity of your office is everything. At the end of the day, laws aren't just rules in a book. They're a reflection of what we as a society value. And when a law specifically calls out the abuse of power by the very people in charge, that makes a huge statement. So it kind of leaves us with this final thought. How do laws like this one shape the trust that you place in your government and public institutions? It's definitely something we're thinking about.
Imagine for a second that you hold a position of power. And I don't necessarily mean you're like a king or a billionaire CEO flying in a private jet. I mean something a bit more grounded, but in a way much more impactful on a daily basis. Imagine you have a badge or a title, Or even just a desk in a government building where you make decisions that affect actual people's lives.
Yeah, it's the kind of power that seems really small until you're the one standing on the other side of that desk.
Exactly. Now imagine a woman walks up to that desk. She needs something from you. Maybe it's a permit for her small business. Maybe she needs a signature on a clearance form so she can travel. Maybe she's just trying to visit a family member who is in custody.
A very vulnerable position.
Incredibly.
Yeah.
And in that moment, there is this invisible line in the sand between you and her, a line that defines professionalism, duty, and, frankly, basic human decency. Today, we are going to talk about what happens when a public officer steps over that line.
And not just steps over it, I mean, in some cases, completely obliterates it. We're looking at a very specific and, quite a disturbing section of the legal code today.
We are.
But it's also a really fascinating study in psychology and the safeguards we try to put on authority.
We are doing a deep dive into Article 245 of the Revised Penal Code. Now, the title alone, it sounds a bit old-fashioned, maybe a little intense. It's called Abuses Against Chastity.
It does sound archaic, doesn't it? Chastity. It brings to mind like Victorian morals and corsets and, fainting couches.
Right.
It really feels like a word that belongs in the 1800s. But if you actually look at the mechanics of the law, what we have right here in our source material, it's remarkably modern in its understanding of power dynamics.
That's the thing that really surprised me. You hear chastity and you think it's going to be about moralizing, but it's not. It's actually about corruption. It's about leverage.
Precisely. It's about the abuse of power, plain and simple.
So that is the mission for this deep dive. We are not here to give some dry legal lecture where we just, recite the statutes word for word.
Yeah.
We want to unpack exactly where the law draws that line for public officers when they're interacting with vulnerable women. We really want to understand the specific legal mechanics of this thing called solicitation.
And this is so crucial. We need to understand why the law treats this specific act differently than just, say, regular harassment or abuse. This is specifically about the abuse of authority.
Yeah.
It's about what happens when the state itself, through its representative, becomes the predator.
Right. And to kick things off, I found something in the notes here that actually it stopped me in my tracks. I had to read it twice.
Okay.
When we think of abuse against chastity, or really any crime involving sexual misconduct, we usually assume there has to be some kind of physical act.
Yeah.
Something tangible happen.
Yeah.
An assault, a touch.
The act, as we'd usually define it in criminal law, the physical component.
Exactly. But looking at this, that's not the case here, is it?
No, it is not. And that is perhaps the most critical aha moment for anyone studying Article 245. You do not have to do anything physical to commit this crime.
Nothing.
The crime can be consummated by a mere proposal.
A mere proposal. Just words.
Just words. That's it. If those words meet a very specific criteria, which I'm sure we'll get into in detail, the crime is finished. The damage to the office and the potential trauma to the victim, it's recognized by the law the moment that proposal leaves the officer's mouth.
That is wild to me. It completely changes how I think about, attempted versus committed crimes.
Right.
Usually if I ask someone to help me rob a bank and they say no, well, that's conspiracy or incitement or something. But I haven't actually robbed the bank yet. Mm-hmm. But here, the asking is the robbery.
That's a great analogy. It really is. It's like the law is saying the intent and the pressure. They are poisonous enough on their own. It's about protecting the integrity of public office.
Yeah, the office itself.
Yes. If an officer uses their position, their official capacity, to pressure someone for sex, the betrayal of public trust has already happened. It doesn't matter if the victim gives in or resists.
So the victim's reaction doesn't determine whether the crime happened.
Not at all. Her refusal doesn't absolve him. His success doesn't change it. The crime is in the asking.
Okay, let's unpack this then. We need to break down the who, the what, and the how, because this isn't a blanket law for absolutely everyone. I can't be charged with Article 245 if I'm just, a guy at a coffee shop trying to get a date and I'm doing a terrible job of it.
Correct. No, this law applies specifically and only to a public officer. That is the first element. You have to hold that official status.
Okay, so why single them out? Why is it worse for a public officer to make a pass at someone than, say, a manager at a private company? I mean, harassment is bad everywhere, but this law puts it in a special, very specific box.
And it comes down to the source of the power. Think about it. A manager at a company has power given by, what? A contract, a business owner. It's economic power, right? I can fire you. That's bad, certainly. No one's denying that. But a public officer, their power comes from the state. It comes from the Constitution. It comes from the people.
It's the social contract.
It is exactly the social contract. When a public officer abuses that power, they aren't just harming an individual. They are eroding the very foundation of the government itself. It implies a breach of a much, much higher trust. When you put on that uniform or sit at that desk, you are an avatar of the state. If you use that avatar to solicit sex, you are corrupting the state itself.
That makes a lot of sense. It's the difference between a bad boss and a corrupt system.
Yeah.
So I have our public officer, that's the who. Now let's look at the what. The source material lists two key actions that can trigger this crime: soliciting and making immoral or indecent advances.
Right, and these two things, while they're obviously related, they can be distinct acts.
Let's focus on soliciting first, because I feel like we use that word pretty loosely in conversation.
Yeah.
You see no soliciting signs on doors, that kind of thing.
Yeah.
But in a legal context, especially here, it has a very, very heavy weight. What exactly is the legal definition we're working with from our source?
According to the source material and the commentaries on it, soliciting in this context means proposing earnestly and persistently something unchaste or immoral to a woman.
Okay, I want to highlight those two adverbs right there. Earnestly and persistently.
They are doing a lot of heavy lifting in that sentence. A lot.
They really are. Let's look at earnestly first. What does that actually mean in a courtroom? How do you prove something was said earnestly?
Earnestly implies you are not joking. This isn't just some banter that landed wrong or an off-color comment. You mean it. It speaks to the sincerity of the desire. The officer actually wants the sexual favor.
So it kills the defense of, oh, I was just kidding around, or it was just a crude remark, I didn't mean anything by it.
Exactly. It removes that ambiguity. If an officer makes a bad joke, realizes it was inappropriate, and immediately apologizes, well, that might be unprofessional. It might get him a reprimand from HR. But it probably doesn't cross the very high threshold of earnestly soliciting under Article 245.
Okay.
The law is looking for that genuine intent to extract something immoral.
And then we have persistently. That one.
Yeah.
That's the scary part to me.
Persistently implies a refusal to take no for an answer. It implies pressure. It implies that the officer is pushing against the woman's will, trying to wear her down. It's what distinguishes a momentary lapse in judgment from a concerted effort to exploit the situation.
It creates a siege mentality for the victim.
It absolutely does. I mean, imagine the dynamic. The officer asks, the woman deflects or says no. He asks again. Maybe he subtly, or not so subtly, reminds her of the power he holds over her case or her situation. He asks again. That is persistence. It turns what might have been a request into a demand.
And this brings us right back to that hook we mentioned at the very beginning. The source explicitly says, crime of abuses against chastity is consummated by mere proposal.
Yes. Reyes, who is a very prominent legal authority cited in these notes, is crystal clear on this point.
So let's play this out. Let's create a scenario for the listener just to make it concrete. An officer is in a room with a woman who needs a permit. He locks the door, he sits down, looks her in the eye, and says very seriously and very persistently that she needs to do something sexual if she wants that permit. She refuses. She manages to get out of the room. He never touched her. He committed the crime.
He committed the crime. The moment he made that earnest and persistent proposal, Article 245 was violated. Done.
That is so powerful. It really emphasizes that the abuse here is the coercion itself, the pressure.
It creates a kind of zero tolerance zone. The law recognizes that for a woman in that specific position, the fear, the confusion, the feeling of entrapment, it all begins with the words. We don't wait for a physical violation to happen before we punish the abuse of authority.
But, and this is where it gets really, really interesting, there's a flip side to this. We have a case study in the notes that deals with the exact opposite scenario.
Ah, yes. You're talking about the case of U.S. versus Morelos.
This is a fascinating counterpoint. So in the mere proposal rule, words are enough. But in U.S. versus Morelos, the whole argument was about what happens when there aren't any words, or at least when the words can't be proved.
Correct. Let's look at the facts of that case because they're pretty stark. You have an accused officer. He is in charge of prisoners.
Okay.
He enters the cell of a woman prisoner, and the source states clearly he had illicit relations with her.
So the physical act happened, sexual intercourse occurred.
It absolutely did. But here is the defense's strategy, and you really have to appreciate the audacity of it. The accused argued that there was a lack of proof regarding solicitation.
Wait, let me get this straight. His argument was Sure, we had sex, but you can't prove I asked for it earnestly and persistently.
That is essentially it, yes. He was trying to use the very specific definition of solicitation as a shield. He argued that because the prosecution couldn't produce, a witness or a transcript of him begging or pressuring her verbally, the elements of this specific crime weren't met. He was likely arguing it was consensual, or at the very least, that the legal requirement of solicitation wasn't proven beyond a reasonable doubt.
That sounds like a loophole the size of a truck. I didn't pressure her verbally, it just happened.
Exactly, and the court saw right through it. They shut that argument down immediately and completely.
How did they justify that? Because technically, I guess he was right. Right. There was no record of the conversation.
The ruling is actually quite simple and powerful. The court states that proof of solicitation is unnecessary when there has been sexual intercourse.
Okay, that feels like common sense, but legal reasoning has to be more specific. What's the logic there?
The logic is what we could call implied solicitation. If you are a public officer, specifically one in charge of prisoners, and you enter a female prisoner's cell and have sex with her, the solicitation is inherent in the act itself. The power dynamic is so completely skewed that the idea of a consensual, non-solicited encounter is legally absurd in this context.
So, if the act happened, the law just assumes you must have solicited it. You don't get to get off the hook just because you were successful in your abuse.
That's a perfect way to put it. Correct. It prevents this absurd situation where an officer who merely asks and is rejected is guilty, but an officer who actually completes the sexual act goes free because no one heard him ask.
It's a crucial safeguard. It covers both ends of the spectrum. The proposal without the act, and the act which then implies the proposal.
It creates a comprehensive net. If you ask, you're guilty. If you do it, you're guilty. There is no safe harbor for this kind of behavior.
It really reinforces that idea you mentioned earlier of the sterile environment. The law is trying to sterilize the prison, the office, the bureau from this kind of contamination.
Yes, creating that zero tolerance zone for this specific kind of exploitation.
Okay, so we know who it applies to, public officer. We know what they have to do, solicitation or advances, and we know it could be just words or the act itself. But here is where the law gets very, very granular. It doesn't just apply to any woman the officer meets on the street, right?
No. And this is a very, very important distinction. If a public officer hits on a woman at a bar on a Saturday night when he's off duty, that's not Article 245. That might be something else entirely, or it might be nothing legal at all. Article 245 requires a specific relationship to exist between the officer and the woman.
A relationship based on his official duties.
Precisely. The source lists 3 specific classes of women, and when you look at them, they seem to represent 3 different types of vulnerability, 3 different ways an officer can have leverage.
That is a perfect way to describe it. 3 categories of leverage. Let's break them down one by one. Class 1. I'm calling this one bureaucratic power. The source describes a woman who is interested in matters pending before the offending officer for decision.
Right. This is the classic pending decision scenario.
But it goes even further than just him being the one to make the final call. The source says it also applies if he is required to submit a report to or consult with a superior about her case.
And that broadens the scope significantly. It means the officer doesn't have to be the ultimate boss. He doesn't have to be the minister or the secretary or the judge.
Right.
He could be the middleman. He could be the investigator who writes the report. He could be the clerk who prepares the file. He could be the guy who writes the recommendation that his boss will likely just sign off on.
Which in any big bureaucracy is often where the real power lives, right? With the person who controls the information.
Absolutely. Think about the dynamic here. A woman has an application, maybe for a business license, a visa, a legal appeal, a land title, something that is critically important to her life.
Yeah.
And it is sitting right there on this officer's desk.
She is in a state of waiting. She is anxious. She is powerless in that moment.
And the officer knows this. He knows that a negative report from him could kill her chances. Even if he can't say yes himself, he can definitely say no, or he can just make the process painfully, endlessly slow. He holds her fate in his hands regarding that specific matter.
So when he solicits her, he isn't just some guy asking for a date. He is essentially saying, even if he doesn't say it out loud, I can make this easy for you, or I can make this very, very hard for you.
Even if he doesn't explicitly state the quid pro quo, sleep with me or I reject your application, the solicitation itself in that context carries the full weight of his administrative power. The woman cannot freely say no because she has a legitimate fear of retaliation against her case.
It's the abuse of that pending matter. He's taking his official duty and using it as a bargaining chip for his personal immoral desires.
Precisely. It corrupts the entire decision-making process. The law wants to ensure that decisions are made based on merit, not on whether someone provides sexual favors.
Okay, so that's the bureaucratic leverage, the power of the pen, so to speak. Now let's move to Class 2. This one feels much more visceral. I'm calling this direct custodial power.
This is the prisoner scenario. The source defines this as a woman who is under the custody of the offender.
And it specifies the offender's role too, doesn't it?
Yeah.
It's not just any officer.
Yes. It specifically mentions a warden or another public officer directly charged with the care and custody of prisoners or persons under arrest.
This brings us right back to that Morelos case we talked about earlier. This is the most direct form of physical control imaginable.
It is. In the bureaucratic scenario, the woman can at least walk away. It might cost her the application, she might lose the license, but she retains her physical freedom. In this scenario, she literally cannot leave.
The officer controls the keys.
He controls the keys, he controls when she eats, when she sleeps, who she is allowed to see, if she gets medical care, everything.
The power imbalance here is total. It's absolute.
Which is why the law is so incredibly strict here. A person in custody has been stripped of their liberty by the state. The state, therefore, has an absolute, non-negotiable duty to ensure their safety. If the person holding the keys uses that position to solicit sex, it is one of the most profound violations of human rights imaginable.
It's terrifying to think about. You are in a cell, you have effectively no rights, and the person in charge of your entire existence comes in and starts earnestly and persistently proposing something immoral. You have nowhere to run, nowhere to hide.
And that is exactly why the Morelos ruling is so important. In that kind of environment, the legal concept of consent becomes a fiction. The environment itself is coercive. A prisoner cannot give true free consent to their warden. It's legally and morally impossible.
Okay, so we have bureaucratic power, that's Class 1.
Yeah.
And we have direct custodial power, Class 2. But Class 3. Class 3 is the one that really gets under my skin. It feels like the most manipulative and cruel of them all.
It is certainly the most insidious, I would agree.
This is what I'm calling leverage over loved ones. The source says this applies when the officer solicits the wife, daughter, sister, or relative within the same degree of affinity of a person who is in his custody.
So, just to paint the picture, you have a man in prison. He is the one in custody. He is helpless. The officer doesn't target him directly for abuse. He targets his wife or his daughter when they come to visit or when they try to bring him food or medicine.
That is just, it's evil. It's using the prisoner as a hostage, basically.
It creates this horrible triangle of pressure. The officer knows the woman is desperate to help her loved one. Maybe she wants to ensure he isn't mistreated inside. Maybe she wants him to get better rations or access to the doctor. Maybe she just wants to be allowed to see him for 5 extra minutes. The officer uses that desperation as a weapon.
And the prisoner, the husband or the father or the brother, is sitting in a cell, completely unable to protect his female relative. He might not even know what's happening.
Exactly. It exploits the family bond. It weaponizes love and loyalty. The officer is banking on the fact that the woman will sacrifice her own dignity to protect her family member from harm.
The source mentions relative within the same degree of affinity. Can we just quickly clarify that term? Affinity, what does that mean legally?
Sure. It's a simple distinction. In legal terms, consanguinity refers to blood relatives, so your daughter, your sister, your mother. Affinity refers to relationships that are created by marriage, so a wife, a sister-in-law, a mother-in-law, a stepdaughter.
So the law is smart enough to cover the immediate family circle, whether it's by blood or by marriage.
Yes. It recognizes that the emotional leverage is the same. Whether an officer targets the prisoner's wife, a relationship of affinity, or his daughter, a relationship of blood, the threat is the same. I have power over your loved one, so you better do what I say.
It really paints a picture of how the law tries to anticipate and close every possible loophole for this kind of abuse. It's not just about the person in the cell, it's about the entire ecosystem of vulnerability around them.
It's acknowledging that this kind of corruption radiates. It doesn't just stay contained in the cell. It affects the family waiting anxiously outside the gate.
So to synthesize all of this, we've basically got a clear checklist. If you are a prosecutor and you're trying to prove this specific crime, Article 245, you need 3 things.
Right. Let's recap the elements provided in our source material. Element 1. The offender must be a public officer. You need to prove his employment, his title, his official capacity.
Check. Got it.
Element 2, the offender solicits or makes immoral advances. And remember, soliciting means that earnest, persistent proposal. It's not a joke. It's not a one-off comment. It's a campaign.
Check. And the mere proposal is enough to consummate the crime.
Element 3, the woman in question must fall into one of those 3 specific classes of vulnerability we just discussed.
Right. Number 1, she has pending business with him. Number 2, she's in his custody herself. Or number 3, she is the relative of someone in his custody.
If you have all 3 of those, you have a case for Article 245.
You do. And notice what isn't on that list of elements. Actual sexual intercourse. You don't need to prove that ever happened to get a conviction. You just need the solicitation and the context.
The abuse of power is the crime.
I want to circle back to one phrase we kind of glossed over a little bit. We talked a lot about soliciting, but the text also says making immoral or indecent advances. The source seems to distinguish these 2 things.
It does, and it's an important distinction. Soliciting is defined as proposing. That implies language. It implies words. I want you to do this. It's a verbal act.
Okay, so what are advances? How is that different?
The expert commentary suggests advances can be broader. It might cover behavioral aspects, physical gestures that fall short of, say, a full-blown assault.
Like what? What kind of thing are we talking about?
It could be touching that isn't quite an assault, but is definitely immoral or indecent in context. Stroking someone's hair, an inappropriate hand on the knee, physically cornering someone in an office.
Things that send a very clear message without having to actually say the words out loud.
Exactly. If soliciting is the verbal proposal, advances are the physical or behavioral actions that convey the very same intent, but notice the qualifier is still there. They must be immoral or indecent.
So shaking hands isn't an advance, but, well, we can all imagine what is.
We can. And again, it's all about context. An action might be completely innocent in one context, but becomes indecent when it's performed by a warden towards a prisoner in a locked cell.
It all comes back to that power dynamic. The context changes the meaning of the action.
Always. You cannot separate the act from the authority of the person doing it. That's the entire point of this law.
This has been a really intense look at just one article of the Penal Code. It's amazing how much is packed into these few paragraphs.
It really is. It's a study in how the law tries to, as I said before, sterilize the environment of public office.
Sterilize. That's such an interesting word choice.
I think it fits. The law wants to create a sterile environment where decisions are made cleanly on the merits, where custody is safe, where the germs of personal desire and sexual exploitation don't get a chance to infect the system.
It's targeting that specific moment where public beauty clashes with personal immorality. It says, if you put on the uniform, if you sit behind that desk, you leave your personal desires at the door.
And if you don't, the law will step in, not just to punish the physical act if it happens, but to punish the attempt, to punish the very betrayal of trust.
It's heavy stuff, but it's really important. It makes you look at the interactions between citizens and officials in a completely different light.
It should.
Yeah.
It reminds us that the honor of the office isn't just a fancy phrase. It's something that has to be actively protected by law if necessary.
Before we wrap up, I want to leave our listener with one last thought to chew on. We talked a lot about that mere proposal rule, the idea that the crime is finished the moment the words are spoken. It makes me think. Usually, we think of law enforcement and criminal justice as protecting our bodies or our property. You know, don't hit me, don't steal my car. Pretty straightforward. But this law seems to be doing something else, something deeper. Since the crime is committed by just asking, isn't the law saying that it values the dignity of the office and the peace of mind of the citizen just as much as their physical safety?
That is a really profound way to look at it. I hadn't thought of it in quite those terms.
It forces us to look at corruption differently, I think. We usually think of corruption as stealing money, kickbacks, bribes, embezzlement. But Article 245 suggests that corruption is also about stealing safety. Stealing that sense of security a citizen should be able to feel when they're dealing with their own government.
That's a powerful takeaway. Corruption is the theft of trust, in whatever form that takes. Whether you are stealing tax money from the Treasury or stealing the peace of mind of a woman applying for a simple permit, you are breaking the exact same sacred trust.
And on that note, we'll leave you to think about that invisible line the next time you walk into a government office. Thanks for listening to this deep dive.
Stay curious and stay informed.
See you next time.
Welcome to the debate. Today, we are opening up the revised Penal Code to examine, well, a very specific intersection of human behavior and state power, We are looking at Article 245, a provision titled Abuses Against Chastity.
Right. And it is a section of the law that sounds a bit archaic on its face. I mean, the word chastity itself feels pretty dusty, but when you peel back the layers, it deals with a very modern and honestly very timeless problem: the friction between public authority and private sexual boundaries.
Exactly. The central question we are wrestling with today is really one of interpretation and of threshold. Article 245 penalizes public officers who solicit or make immoral advances to women under specific circumstances. But the tension lies in the definition of the act itself. So, does the crime of abuses against chastity require a pattern of relentless pressure, what the text actually calls earnest and persistent behavior? Or does the sheer weight of a public officer's authority make a mere proposal criminal by default?
Yeah, it is the classic conflict between the spirit of the law and the letter of the law. And I will be arguing today that words matter. The legal text demands specific thresholds. It defines solicitation in a very specific way. And I represent the position that conflating a single, perhaps lapse in judgment proposal with criminal solicitation, well, it ignores the precise definitions we find in the code.
And I see why you think that, but my position is that this law is designed to strictly penalize the betrayal of public trust. When you hold the keys to a prison cell or you hold the stamp on a pending decision, the power dynamic is so lopsided that any proposal is inherently coercive. So I'll be arguing that the crime is consummated by the proposal itself, regardless of persistence.
Well, we have the text, we have the case law, and we clearly have two very different ways of reading them. Let's get into it.
Let's start with the architecture of the law itself. Article 245 isn't just a blanket ban on public officers dating. It is a shield constructed for specific classes of vulnerable women. The code identifies three distinct scenarios where the officer's power is most dangerous. First, women who have matters pending decision before the officer. Second, women who are under the direct custody of the officers, prisoners essentially. And third, the female relatives, specifically the wife, daughter, sister, or relative within the same degree of affinity of a person in custody.
Right. The scope is specific. And I think that specificity is important because it tells us the legislature wasn't trying to police all morality. They were targeting specific pressure points in the justice system.
Right, it's specific because these are situations where the woman cannot simply walk away. She is bound to the officer by the legal process. Now, here is the crux of my argument. We have a source note from Reyes, who is a preeminent authority on the penal code, stating quite clearly that the crime of abuses against chastity is consummated by mere proposal. That is a powerful phrase, mere proposal. It suggests that the moment the words leave the officer's mouth, the line has been crossed and the crime is complete. The officer has leveraged his public office for private immoral gain.
I hear that, but I just don't buy that interpretation. Let me tell you why. You are leaning heavily on a secondary interpretation, but I am looking at the elements listed right there in the source material. Look at element 3b, subsection 1. It defines exactly what soliciting means in this context. It says soliciting means proposing earnestly and persistently something unchaste or immoral to a woman.
Earnestly and persistently.
Yes, persistently. That word has to mean something. If the law intended for a mere proposal, a single ask, a one-time comment to be a felony, it would not have included the requirement of persistence. Mere implies a singular, perhaps isolated event. Persistent implies a pattern, a refusal to take no for an answer, a campaign of pressure. If an officer asks a woman out and she says no and he drops it immediately, has he been persistent? I would argue no. He might have been unprofessional, perhaps immoral, but I really question if he has met the high bar of Article 245.
That is an interesting point, though I would frame it very differently. You are treating persistence as a function of time or frequency. I am treating it as a function of intensity derived from power. When a warden asks a prisoner for a sexual favor, does he need to ask 5 times for it to be earnest? The first ask is already heavy. with the weight of the state.
But you are effectively erasing a word from the statute. You are asking us to ignore persistently because of the context. You are asking the court to rewrite the dictionary definition of the word to fit the crime.
I am saying the context defines the persistence. Think about the reality of that interaction. If a warden says to a prisoner, "Do this for me," that instruction doesn't disappear just because he stops speaking. It hangs in the air. It persists in her mind every single time he walks past the cell. The proposal is persistent because the threat is persistent.
That is a very poetic interpretation, but criminal law requires strict construction. If we accept the mere proposal theory that one ask is enough, then the definition in element 3b, subsection 1, is just contradictory. Why define soliciting as persistent if the crime is consummated the exact moment the proposal is made? It renders the adjective useless.
Because the mere proposal in this context is never just a proposal. It is a threat wrapped in a proposal. Let's look at the advances mentioned in the text. Element 3b, subsection 2 says the advances must be immoral or indecent. When a public officer, say a judge with a case file on his desk, turns to the female litigant and makes an immoral advance, the persistence is built into the situation. She cannot escape the situation. The earnestness comes from his position.
I come at it from a different way. Words have limits. If the legislature wanted to criminalize any immoral proposal, they would have written that. They wrote earnestly and persistently. This suggests they wanted to filter out the ambiguity of a single interaction. They wanted to capture the officer who hounds, who pressures, who uses the duration of his focus to wear the victim down.
But doesn't that endanger the victim? If the law requires her to endure a persistent campaign before the police can step in, aren't we failing to protect her? Are we telling the woman she has to say no 3, 4, 5 times before the officer has actually committed a crime?
We are debating the definition of a specific crime, not the morality of the act. Of course it's wrong. It is entirely wrong. But to charge someone under Article 245, you need to check the boxes. And one of those boxes is persistence. If you ask once and stop, you have not been persistent. It might be sexual harassment under a different administrative code, but is it this specific felony?
I'm not convinced by that line of reasoning because it ignores the precedent that helps us interpret this. We really have to talk about U.S. vs. Moralos. This is a decided case, 29 Phil 572, that directly addresses the issue of proof regarding solicitation.
I was waiting for Morelos. It is definitely the counterweight to my argument, but I'd argue it is a very specific type of weight.
It is a decisive weight. In U.S. versus Morelos, we have an accused who is in charge of prisoners. He entered the cell of a female prisoner, and the record states they had illicit relations. Sexual intercourse actually occurred. Now, here is the key point. The defense argued that there was a want of proof to show solicitation. They essentially made your argument. They asked, where is the proof of the begging? Where is the proof of the persistence? They argued that since there was no record of him hounding her, the element wasn't met.
And the court rejected that defense.
They rejected it outright. The source text says explicitly, proof of solicitation is unnecessary when there has been sexual intercourse. The court looked at the fact that he was the warden, she was the prisoner, and the act happened. They didn't need a transcript of him asking earnestly and persistently. The act confirmed the abuse. And this really supports the mere proposal or even implied proposal theory. The power dynamic is so strong that the solicitation is presumed from the outcome.
That is a compelling argument, but have you considered the distinguishing fact in Morelos? Sexual intercourse. The crime was physically consummated. In that scenario, the logic absolutely holds. Obviously, there was a solicitation or at least a coercive pressure that led to the act. The sex itself is the proof of the solicitation success. But Article 245 is often charged when there is no intercourse, when it is just words.
But the principle remains.
Does it, though? If there is no intercourse, if we are strictly in the realm of advances, can you still say proof of solicitation is unnecessary? The Morelos ruling is a shortcut for when the physical evidence exists. It warns us not to get hung up on words when the deed is done. But if the deed isn't done, if we are only judging the proposal, then the earnest and persistent requirement must come roaring back. You can't use Morelos to say we never need to prove persistence. You can only use it to say we don't need to prove persistence if they actually had sex.
I think that's a dangerous distinction. You are suggesting that the officer who tries and fails because the woman is strong enough to resist is somehow less criminal than the one who succeeds. The Reyes interpretation that the crime is consummated by mere proposal applies to the crime of Article 245, not the act of sex. The crime is the abuse against chastity. The abuse happens when the words are spoken.
But if the words are spoken once, loosely, without the earnestness required by the definition?
An officer proposing sex to a prisoner is never loose. It is always earnest. It is always heavy.
Let's shift the ground slightly then. We've been talking about prisoners, which is perhaps the most extreme power dynamic. But Article 245 covers another group, one that is perhaps more bureaucratic and a bit less physically coercive. The first class of women, those with matters pending.
Yes, woman interested in matters pending before offender for decision. This covers the vast machinery of government. Licenses, court cases, permits.
Right, but it goes further. The text says, or with respect to which he is required to submit a report to or consult with a superior. This broadens the net significantly. We aren't just talking about the judge or the warden anymore. We are talking about the consultant, the guy who writes the report that goes to the guy who makes the decision.
Correct, and this is vital. It acknowledges the nuanced layers of bureaucracy.
But look at the delusion of power here. If I am an officer who merely consults or submits a report, I do not have the final say. I cannot single-handedly determine the fate of the woman's application or case. So the dissenter in me asks, does a solicitation from this lower-level functionary carry the same coercive weight as the warden? If a clerk says, let's get dinner, is it truly the same abuse against chastity?
Absolutely it is. In fact, I would argue that the ambiguity of their power makes it more dangerous. When you are a citizen dealing with a government agency, the internal hierarchy is a black box. You don't know if the person consulting has the ear of the director. You don't know if that report is a formality or the deciding factor.
So the perception of power substitutes for actual power.
The law recognizes that bureaucratic influence is a tool of coercion. If an officer has to consult with a superior, that consultation is a leverage point. If he solicits the woman, the implied threat is, be nice to me, or my consultation will go poorly for you. The victim cannot risk it. That is why the law specifically includes these lower-level actions like reporting and consulting. It acknowledges that you don't need to be the king to be a tyrant. You just need to be a gatekeeper.
I see the logic, but it brings us right back to the definition of the advance. If the officer's power is merely consultative, and this proposal is not persistent, are we criminalizing awkwardness? Suppose a consultant asks a woman with a pending file for a date. She says no, he says okay, no problem, and files the report fairly. Has he violated Article 245? Under your mere proposal theory, he has.
Yes, he has. He used the access granted by his office to make an advance on someone entirely dependent on his work. That is the definition of corruption of office. He shouldn't be asking for the date in the first place.
Even if he wasn't earnest and persistent, even if the text of Element 3B, subsection 1 is ignored,
the proposal itself, in that context, is the abuse. It changes the nature of the transaction from professional to predatory.
that is a very strict liability standard you are applying to human interaction. It implies that a public officer ceases to be a human being with a private life the exact moment a file lands on their desk.
The standard is high because the stakes are high. When you accept the badge or the office, you accept that limitation. And speaking of stakes, we have to look at the third category of victims. This, to me, is the most chilling part of the statute. It doesn't just protect the woman in custody. It protects the wife, daughter, sister, or relative within the same degree of affinity of the person in custody.
Yes, this is the collateral damage provision.
I call it the collateral leverage provision. This is the strongest evidence that the crime is about leverage, not just persistence. Why does the law include the sister of a prisoner? because the officer knows he can't get what he wants from the prisoner, or perhaps he wants to use the prisoner's suffering to extract favors from the family. Be nice to me or your husband in cell block 4 is going to have a hard time.
It is certainly a lever. It attacks the prisoner by proxy.
And in this scenario, does the officer really need to be persistent? If a warden walks up to a prisoner's wife in the waiting room and whispers a mere proposal, the threat is instantaneous. It is terrifying. The lack of persistence doesn't make it less of a crime. The mere proposal is a loaded gun pointed at her husband's well-being.
I concede the emotional weight is enormous. But here's where I get stuck on the immoral or indecent advances language in Element 3B, subsection 2. When you're dealing with third parties, people who are free citizens not in custody themselves, the line between a friendly interaction and a criminal advance needs to be sharp.
How so?
Well, wardens and guards interact with visitors constantly. If we loosen the definition of advances or ignore the earnest and persistent requirement, we risk criminalizing benign interactions. If a guard asks a visitor, "You look nice today," is that an advance? Is it immoral? If the mere proposal standard rules, then any comment that could be construed as romantic becomes a felony just because of the husband in the cell.
"You look nice today" is hardly an immoral or indecent advance. The law requires the content to be unchaste.
But unchaste is subjective. And if we strip away the requirement for persistence, we remove the buffer that clarifies intent. Persistence proves intent. Persistence proves that it wasn't a misunderstood compliment, but a targeted pursuit. In the case of the prisoner's wife, the stakes are high. I absolutely agree. But that is exactly why the elements immoral, indecent, earnest, persistent must be strictly met. We cannot convict based on the implication of power alone. The act itself must meet the statutory definition.
I think you are placing too much faith in the ability of a text to capture the nuance of intimidation. The text says advances must be immoral or indecent. That is the quality of the act. The res no clarifies that the proposal consummates the crime. You are essentially asking for the officer to harass the woman before we call it a crime. I am saying the moment he puts the trade on the table, sex for safety or sex for a decision, the crime is done.
But putting the trade on the table implies a specific type of proposal. What if the proposal is ambiguous? What if he just invites her for coffee? Is coffee unchaste?
If the coffee's the gateway to the leverage, yes.
See, that's where it gets slippery for me. You are reading the intent into the action based entirely on the position of the actor. A guard asking for coffee is just a guard asking for coffee until you apply your filter of inherent coercion. And while that might be true sociologically, legally, I worry about convicting people for what they might imply rather than what they actually do. Earnest and persistent are guardrails against that slippage.
And I worry about the guardrails protecting the predator. If we require persistence, we are giving the officer a free pass for the first attempt. He can test the waters with the prisoner's wife. If she recoils, he backs off, and under your definition, no crime occurred. But the damage is done. She now knows the person guarding her husband sees her as prey.
That is a fair critique. The free pass problem is real. But the alternative, the zero tolerance interpretation, creates a thought crime scenario where a single clumsy sentence can end a career and start a prison sentence.
It's not a thought crime if he vocalizes it. It's a speech act that carries the force of the state.
We are circling the drain of the same fundamental disagreement here.
We are, so let's bring this to a head. We are looking at Article 245 as a tool for cleaning up the public service.
Or as a precisely defined criminal charge that shouldn't be expanded beyond its text.
Right. To summarize my position, Article 245 exists to purify public service and protect the vulnerable from those who hold the state's power. Whether it is a warden with a prisoner's wife or an official with a pending report, the mere proposal is the crossing of the line. The power imbalance fills in any gap left by a lack of persistence. The Rennes interpretation is correct because it recognizes that when a public officer asks for something unchaste, he isn't asking as a man, he is asking as the state, and the state does not get to make immoral advances on its citizens. U.S. versus Morlos proves that we don't need a recording of the solicitation to know the abuse occurred.
And to summarize my view, we must adhere to the text to ensure justice is predictable. Element 3b, subsection 1, explicitly defines soliciting as proposing earnestly and persistently. We cannot just wish those words away. While I acknowledge that the abuse of power is repugnant and that Morelos allows for a shortcut when intercourse actually occurs, for the vast majority of cases involving advances, the rigorous definition of solicitation must be met. A single proposal, no matter how distasteful, does not equal persistence. We must protect the integrity of the penal code by applying it only when the strict elements, including persistence, are actually proven.
It really is a balance between the protection of the victim and the protection of the accused rights to a clear definition.
Precisely. Is the crime in the persistence of the ask, or is the crime inherent in the power of the asker?
That is the question Article 245 poses to every legal practitioner. We hope this discussion has illuminated the mechanics of this provision for you and gives you something to think about.
It's a complex article, and as always, the devil is in the definitions. There's definitely a lot more to explore in the text.
Thank you for joining us on The Debate.
Until next time.